Fidelity to law is the essence of peace, opined Professor Eugene Rostow, former Dean of Yale University Law School, Under-Secretary of State, and a co-author of the November 22, 1967 UN Security Council Resolution 242. Rostow resolved that under international law, Jews have the same right to settle in the West Bank as they have in Haifa. Professor Rostow determined that according to Resolution 242, which he co-authored, Israel is required to withdraw from territories, not the territories, nor from all the territories, but some of the territories, which included the West Bank, East Jerusalem, Gaza Strip, and the Sinai Desert and the Golan Heights. Moreover, resolutions calling for withdrawal from all the territories were defeated in the Security Council and the General Assembly. Israel was not to be forced back to the fragile and vulnerable 9 to 15 mile wide lines, but to secure and recognize boundaries agreed to by the parties. In making peace with Egypt in 1979, Israel withdrew from the entire Sinai, which amounts to more than 90% of the territories occupied in 1967. Former President of the International Court of Justice, Judge Stephen Schwebel, stated the 1967 Israeli conquest of territory was defensive rather than aggressive, as indicated by Egypt's prior closure of the Straits of Tiran, blockade of the Israeli port of Eilat, and the amassing of Egyptian troops in Sinai, coupled with its ejection of the UN Emergency Force and Jordan's initiated hostilities against Israel. The 1948 Arab invasion of the nascent state of Israel further demonstrated that Egypt's seizure of the Gaza Strip and Jordan's seizure and subsequent annexation of the West Bank and the Old City of Jerusalem were unlawful. Between Israel acting defensively in 1948 and 1967, according to the UN Charter, on the one hand, and her Arab neighbors acting aggressively in 1948 and 1967 on the other hand, Israel has better title in the territory of what was British Mandate Palestine, including the whole of Jerusalem. It follows that modifications of the 1949 armistice lines among those states within former Palestinian territory are lawful. The legal status of Judea and Samaria is embedded in the following authoritative, binding, internationally ratified documents which recognize the area for what it has been, the cradle of Jewish history, culture, aspirations, and religion. Number 1, the November 2nd, 1917 Balfour Declaration, issued by Britain, calling for the establishment in Palestine of a national home for the Jewish people. Number 2, the April 24, 1920 resolution by the post-First World War San Remo Peace Conference of the Allied Powers Supreme Council entrusted both sides of the Jordan River to the mandate for Palestine for the establishment of a Jewish state. The mandatory will be responsible for putting into effect the Balfour Declaration originally made on November 2, 1917 by the government of His Britannic Majesty and adopted by the said powers in favor of the establishment in Palestine of a national home for the Jewish people. It was one of over 20 mandates, trusteeships, established following World War I, responsible for most boundaries in the Middle East. Number 3, the July 24, 1922 mandate for Palestine was ratified by the Council of the League of Nations entrusted Britain to establish a Jewish state in the entire area west of the Jordan River, as demonstrated by its 6th article, to encourage close settlement by Jews on the land, including state lands and wasteland. The mandate is dedicated exclusively to the Jewish national rights. On July 23, 1923, the Ottoman Empire signed the Treaty of Lausanne, which included the mandate for Palestine. And number 4, the October 24, 1945, Article 80 of the UN Charter incorporated the mandate for Palestine into the UN Charter. Accordingly, the UN or any other entity cannot transfer Jewish rights in Palestine, including immigration and settlement, to any other party. The November 29, 1947 UN General Assembly Partition Resolution 181 was a recommendation lacking legal stature, superseded by the mandate for Palestine. The 1949 armistice non-peace agreements between Israel and its neighbors delineated non-territorial boundaries. The 1950 through 1967 Jordanian occupation of Judea and Samaria violated international law and was recognized only by Britain and Pakistan. According to Article 80 of the UN Charter and the mandate for Palestine, the 1967 War of Self-Defense returned Jerusalem and Judea and Samaria to its legal owner, the Jewish state. Legally and geostrategically, the rules of belligerent occupation do not apply to Israel's presence in Judea and Samaria, since they are not foreign territory, and Jordan did not have a legitimate title over the West Bank. Moreover, the rules of belligerent occupation do not apply in view of the 1994 Israel-Jordan Peace Treaty. The 1949 Fourth Geneva Convention prohibits the forced transfer of populations to areas previously occupied by a legitimate sovereign power. However, Israel has not forced Jews to settle in Judea and Samaria, and Jordan's sovereignty there was illegal. The 1993 Oslo Accord and the 1995 Interim Agreement stipulated that the issue will be negotiated in the permanent status negotiations, enabling each party, Israel and the Palestinians, to plan, zone, and build in the areas under their control. If Israeli construction prejudges negotiation, then Arab construction, which is dramatically larger, dramatically prejudges negotiation. Finally, the term Palestine was a Roman attempt following the 135 CE Jewish rebellion to eradicate Jews and Judaism from human history. It substituted Israel, Judea, and Samaria with Palestina, a derivative of the Philistines, the arch enemy of the Jewish people, whose origin was not in Arabia, but in the Greek Aegean islands. The campaign against Jewish settlements in Judea and Samaria is based on gross misperceptions and misrepresentations, fueling infidelity to law, which undermines the pursuit of peace. The next video will highlight the growth of Israel's economy.